Hello everyone, I'm Anuj and I'm a legal intern with LEXIS and Company, and this is the second part of the video presentation, which and the topic was impossibility to contract and doctrine of frustration. So let's continue with the second part of the video. So the principle is not just confined to physical impossibility, but also to those contracts where performance of the contract is simply possible, but the object the parties had in mind has failed to materialize. The specific grounds for supervening impossibility are like destruction of subject matter, which was in the case of Taylor versus Caldwell, as I mentioned in the first part of the video, and also in the case of Narasu versus PSV Iyer, a contract to exhibit a film in a cinema hall was held to have become impossible because of heavy rainfall and the rear hall of the theater collapsed. The second condition is, second ground is the change of circumstance. The performance may not be literally impossible, but may be impracticable and useless from the point of view of object and purpose. In the case of Joseph's steamship versus Imperial Corporation Limited, the ship was chartered to load a cargo, but on the day before she could have been processed to her berth, an explosion occurred in the auxiliary boiler, making it impossible to undertake the cargo making it impossible to carry the cargo and undertake the voyage at the scheduled time. But the House of the Lords held that the change in the circumstances amounted to the frustration of the contract. Further, the third specific ground under this is the non-occurrence of contemplated event. In the case of Krell versus Henry, the defendant hired a flat on Pall Mall for the sole purpose of viewing King Edward VII's coronation process. The price agreed was 75 pounds for 2 days. The defendant paid £25 deposit due to illness of the king and the coronation the coronation was cancelled. Consequently, the defendant did not use the flat. So under this condition, the claimant sought to claim the outstanding £50, and it was further held that the contract was frustrated as cancellation of the procession deprived it of its commercial purpose. The claimant's action for breach of contract was thus unsuccessful. The fourth specific ground under this is the death or personal incapacity of the promisor. Under the case of Robinson versus Davison, the defendant was too ill to perform and play the piano in theatre, and hence he was not held liable. And the fifth condition or the specific ground was government or legislative intervention. Under the case of Man Singh versus Khazan Singh, the sale of trees forbade by government, hence contract discharge between certain parties. Further, the appellant in the case of Buthalinga Agencies versus Paryaswamy, the contract for sale of imported crockery held to be void when such sale was banned. Har Prasad Chaube, and another case of Har Prasad Chaube versus Union of India, the appellant bought coal belonging to the railway company and made full payment and applied for wagons so that the coal could be transported. The coal commissioner refused to provide wagons on the ground that the coal was meant for local use only. No such conditions existed at the time of the auction. Held frustrated. Hence, it was held that the contract was frustrated. The sixth specific ground under this is the intervention of was. However, if there are any other ways to perform the contract, then the contract remains valid. Under the case of and this is a very important case where the case's name is Basanti Batragalia versus River Steam Navigation Company Limited, and under this the defendant, a common carrier, agreed to deliver the goods. To deliver the goods to the plaintiff from West Bengal to East Pakistan by inland navigation. War broke out between India and Pakistan, and the contract was held frustrated. So the cases which there are also some provisions or certain conditions where the cases cannot be covered by supervening impossibility. For example, self-induced frustration and difficulty of performance and commercial unremunerative. For under this condition, there was an abnormal rise of rainfall. Under this condition, there was an abnormal rise in the price of a sudden depreciation of the currency and an unexpected obstacle to execution, etc., does not make the contract void. The Contentional Construction Company versus State of Madhya Pradesh was not open to claim extra cost towards the rise in the prices of material and labor. Payment to be made according to the payment has to be made according to the contract only. So this was the total concept of doctrine of frustration and impossibility of contract, and I hope I was able to explain the concept and the various provisions and the case laws under these two clearly, and give you a brief about it in the two videos. So thank you.